The mediator is listening to every side. The mediator therefore may have questions, comments, places to probe, suggestions, either privately or in public session. May have questions for you and your client that raise issues that either the mediator is seeing or that the other side has already raised. You can respond argumentatively.
We have them dead to rights. They're dead in the water. This case is a slam dunk. The law is totally in our favor. They can't possibly win on the law.
You can respond with only the claims that you would raise in court.
If we make a dispositive motion, it's going to cost them a lot of money, it's going to cost us a lot of money, and their case is going to be thrown out. So they might as well save all that and settle the case now.
That's not making great use of the mediator. And that's because if the mediator is pushing on any of these things, there are areas of tension that the mediator is seeing getting in the way of reaching a resolution. Answer the questions as best you can. Explain what your concerns are. If the mediator seems to misunderstand something, this is exactly an opportunity to correct it. You don't need to respond defensively. You don't need to respond argumentatively. You need to respond effectively. If the mediator is asking questions or pushing back or raising issues that you hadn't considered or encouraging you to consider other things than what you had put on the table, take that as coaching. The mediator is saying those things for a reason. Learn from that and use it in ways that guide the way that you present the information or that you frame or shape what you're going to say. The mediator may question the timeline. For example, does delay hurt you? Does it help you?
The longer it takes, the better.
The mediator may ask you questions about your client's concerns about expense and what exactly will make things worse or better over time.
We can wait her out. My client has the money to keep this case going until the end of time. She'll wear out. She'll run out of money, and we're happy to have her do it, so she should settle now.
The mediator may remind you that risk is inherent in any conflict that any parties experience.
We know what mediators say, and we know what is usually true, which is that litigation costs too much, it diverts the time of the client, it's emotionally draining, case should settle. But those things don't apply here. Our client believes he's right. He doesn't want to be held up.
The mediator may remind you that the objective in the mediation is a business resolution that works for every party, not the legal resolution that might take place if the mediation does not result in a settlement.
You know how to do your job, but I know how to do my job, and my client knows how to run his business. So all these things you say about cost and time and pressure and reputation, those are for other cases. Those are for other people. It doesn't apply to my client. Doesn't matter here. We don't need to hear from you on this. Don't waste your breath.
This is not the time or the place to argue for the purpose of persuading anyone. This is the time and the place to put out ideas and possible resolutions that will allow parties to reach solutions that everyone can live with, which is ultimately in their best interest. Lawyers are often competitive people. We care deeply about our cases and our clients. Sometimes that can get us a little too committed. Mediators can help us move beyond that. They can help us see ways to achieve a resolution, to solve a problem that we ourselves might not have come up with alone. Use them for that process. Use them for their expertise and skills rather than trying to persuade them, and you yourself will be the best possible advocate for your client in that setting.